We are on day 3 of waiting for a prior authorization so I can get more ADHD medicine, guys. So even if this wasn't Friday, this morning report was going to have a lot of Aloha in it. But too much has happened for me to leave you hanging over the weekend, and so I say happy Aloha Friday, everybody. I'm Brino, and this is the morning report on the federal courts for November 7th, 2025. Do me a favor, double tap your screen, comment which story has you a little confused right now. Watch the first minute, even if you're coming back later, so we hit the FYP. Check my stack and my socials this weekend. The link's in my bio. Consider supporting me with Venmo, wishlist, anything. I appreciate it all. All right, grab a coffee. Let's get into it. I'm going to start with the Supreme Court issuing a stay that will allow the Trump administration to only print birth sex on passports, at least for now, while the case is pending. This is Trump v. Orr. So I want to tell you guys two things to understand this case a little better. Number one, it is tempting to run to the conservative court well on this one and blame this on the court being conservative, but part of this anyway is just the court being the court. See, there is a portion of this that would require the Supreme Court to recognize that there is a class of people known as transgender people who exist. Recognizing that classes of people exist is something the court really hates doing. Because once the court recognizes that a group or class of people exists, it has to start dealing with whether that class is being treated properly or not. So it tends to just cover its eyes and pretend. For years, even as the court was recognizing rights for gay people, they were twisting themselves into pretzels to explain why they weren't actually recognizing rights for gay people. It's always very delicately about privacy or something, and that's what the court has done for decades. This is not new. Not saying it's good, it's just not new. So my favorite story about this is one of the justices in 1982 or somewhere around there telling his gay clerk that it is not possible that there are gay people everywhere because, quote, I've never met one. So pop that in your head. Second thing, the court said they made this decision mostly based on a finding that there was no harm. But the next time a beefy bearded dude gets stuck in a war zone because he can't prove that this is his passport even though it says female, I think we're all going to recognize that no harm is objectively not correct. So while I recognize the class issue, I think they made an interpretational mistake here, but what I think is, as usual, irrelevant because the court does not allow Aloha shirts on the bench. Still, this is temporary. This is just a procedural stay. The case will continue at the district court level where the judge needs to probably lean into a finding of harm. And now the judge has marching orders. All right. Yesterday, a D.C. court found Sean Dunn, the famous sandwich tosser of U Street, not guilty on a misdemeanor charge of assault. I made a longer video on the Fifth Amendment implications of that decision yesterday, which you can go watch, as well as a really long video on the history of juries, which I just put in my stories. And you get to see my old hair, so that's fun. Now, as a reminder, after federal troops began walking the streets of D.C., Mr. Dunn threw a Subway sandwich at one of them and was arrested for assault. U.S. Attorney for the district, Janine Pirro, brought this case in front of a number of grand juries who all refused to indict him for felony assault, so she brought a misdemeanor assault case which doesn't require a grand jury, but it still requires a petit jury to convict. That's what we call a regular jury. And after a series of failures in front of grand juries, it's not a huge surprise that a local petit jury also wouldn't convict him. Now, a few of you did push back about jury nullification and the right of a local jury to essentially ignore the law. But this is the purpose of the jury and has been for generations. If you watch my really long video on juries, you'll see this goes back about 1,000 years. But this particular iteration is rooted, among other things, in King George III's decision to bring all British soldiers back to England to face British juries in American murder trials rather than American juries, after British soldiers were tried in Boston following the Boston Massacre. Americans did not like that one bit, so we have demanded ever since that a local jury be allowed to decide whether or not the accused will be convicted of the crime as a check on government power. This is a straight up we the people thing here, about as democratic as you can get. And this is the same thing that may play into Letitia James' case and James Comey's case. The DOJ is very concerned about how juries are going to respond to these trials across the board because Americans are skeptical of prosecutorial overreach, and this is how we prevent it. For now, though, Mr. Dunn, who I did accidentally call Mr. Duffy yesterday, is free to go, so good for him. Speaking of, yesterday, a magistrate judge in James Comey's case criticized the Justice Department for what he called an indict first, investigate later approach, which is sort of exactly what I've been talking about here. So here's the general idea. There was a whole hullabaloo back in 2020 because FBI Director Andrew McCabe suggested in a Senate hearing that a leak to the media had been authorized by James Comey. And this was a particular leak, not just general leaking. And that may not be what Andrew McCabe said. That's not the point for today. So Comey came to Congress, and we're talking about this particular leak in Congress, and Ted Cruz asked him if, as McCabe had said allegedly, Comey had authorized it, and Comey said no. So this whole criminal trial is an allegation that Comey was lying on that day when he said that. Now, unrelated to that leak, Comey was apparently friends with a journalist or something like that, and may have talked to that person about something else. And if I'm understanding this right, now that the Justice Department realizes they probably don't have a case on that first question, they're trying to shift the story to say that Comey technically lied because he also had talked to a journalist about a different thing that wasn't discussed in Congress. So when Ted Cruz asked him if he'd authorized a leak and he said no, he may have been lying about this other leak. So I think that's what's going on. If you're confused, I sure as hell am. But as the judge said yesterday, this indict first, ask question later approach isn't really how we do criminal law. And when the DOJ got an indictment against Comey, what did they tell the grand jury to get it? Because if they told them the first story and it wasn't true, then they lied to the grand jury to get an indictment. And so Comey's attorneys have asked for a copy of the grand jury testimony, and the judge has issued an order compelling them to hand it over. If it looks like they lied to the grand jury, we may be looking at another round of vindictive prosecution and maybe some more disbarments down the road. And by the way, assuming my version of this story is correct, which it's probably close, but it's a little confusing, it's still not clear that even the second story is true, the one about the journalist friend. But it does appear that DOJ is shifting their prosecution strategy to that version because, I don't know, they don't have enough evidence for the original accusation. And so, as the judge said, quote, "The procedural posture of this case is highly unusual." So naturally, the government has filed an opposition to the judge's order to turn over the grand jury testimony. We'll see how that goes. All right, last thing, I'm going to check in on a situation that is shifting related to SNAP benefits. This story changes by the minute. Here's what I got right now. So there are two different cases related to SNAP benefits. There's one in Rhode Island, one in Massachusetts. Both judges have issued temporary restraining orders requiring the federal government to do something related to paying out SNAP benefits. But the orders are a little different, so I'm going to try my best here. The Massachusetts order is a little more flexible from what I can tell. It said you have $5 billion in this emergency fund. You're not going to be allowed to just let people starve. You can decide how you're going to handle this, but let me know by Monday, this past Monday. And the USDA said on Monday, quote, "The USDA is making all of the contingency funds available to the states for a partial payment," end quote. But what they hadn't agreed to was to tap any other sources of funding to fully fund SNAP. This was an agreement to partially fund SNAP. Well, the Rhode Island judge said, you got the money, pay it out, all of it. And the USDA has appealed that TRO. So if I'm getting this right, the USDA is going to pay like half of the money to people, but not all of it for now. But the messaging has been very confusing because we govern by tweet now. And Donald Trump himself one day said, oh, totally, I'm paying this all out. And then he said, never mind, I'm not paying any of it out, which I think is what ticked off the Rhode Island judge. This is all made even more confusing by the fact that the news media doesn't seem to realize that there are two cases. I mean, some of them probably do, but I just read an article that starts with Boston, Massachusetts, and then starts talking about the Rhode Island case. And then all it says is that the case requiring the administration to pay is being appealed. But some of the payments have already gone out, which is confusing, but maybe a little less confusing if the administration is complying with one court but not the other. But again, this is all kind of a guess because I need to see what's actually happening. But you guys should at least recognize there are two cases, and that may be why this is an extra level of confusing. By the way, the administration could appeal the other case at any moment, but I don't see an appeal in the Boston case as of this second. All right, folks, that is your Aloha Friday morning report. Check out the link in my bio if you like what I do. Mahalo and fa'afatai for watching, everybody, and manuia leaso. Have a great weekend.